What approach should block managers be taking in respect of reactive repairs?
Well, yeah, I do have quite a lot to say about this topic. I'll try and keep it as brief as possible. I want to begin by saying that I'm going to cover the legal position, and what follows is subject to the caveat that the legal position doesn't always see eye to eye with the practical reality on the cold face. So I'll tell you what the law says. I'll leave it to my esteemed colleagues Andrew and Nigel to inject a bit of common sense to whatever I say subsequently. But the law is important, and I'm going to cover 2 points. The first point is the impact of the COVID-19 emergency measures on contractual obligations on the part of landlords and so on to repair the common parts of buildings. And the second point I'm going to talk about is the restrictions on movement and gatherings and the impact that might have on your ability to carry out repairs. So the first point's an important one, and I can deal with it relatively quickly, and that is that the emergency COVID-19 measures do not alter in any way the existing contractual repairing obligations on the part of a landlord or a residential management company or RTM company under the lease. So if part of a building's fallen into disrepair and your client is responsible for maintaining it, that obligation remains unaffected by the COVID-19 legislation. There are 2 main pieces of legislation: the Coronavirus Act 2020 and the Health Protection Coronavirus Restrictions England Regulations 2020, which introduce a variety of measures in relation to forfeiture of commercial leases and the suspension of possession proceedings in relation to residential tenancies, but nothing has an effect on other obligations in leases like repairing obligations. So the starting point is that you're still responsible, and there are some interesting arguments that I'll touch on that have been doing the rounds in legal circles, arguments that I suppose are attempts to get around these sorts of obligations. But the first is one which is based on case law, which suggests that an individual can be released from an obligation if it's impossible for them to perform that obligation due to a change in the law. There's a case, John Lewis and Viscount Chelsea, where John Lewis was released from an obligation to demolish and build a structure because it became Grade 2 listed. And so some people have been saying, oh well, the coronavirus measures effectively make it impossible to do these things. But I don't think that works, because it's not impossible to carry out repair works. It may be more difficult, but it's not impossible. There are other arguments, implied terms based on the officious bystander test, or sometimes called the business efficacy test, which is where a contract doesn't work for some reason, so you imply a term into it to make it work. But again, I think leases do still work. I don't think that the coronavirus doesn't make it impossible to carry out necessary repairs. So I don't think those arguments are particularly strong. I think the contractual obligations still hold water. And that brings me on to another point, which is about time limits for compliance. And this is, I think, even more important in the current climate. And that, I think that the starting point is a case called British Telecommunications and Sun Life Assurance, which says that where there's an obligation to keep a building in repair, or part of a building in repair, that obligation is broken as soon as it falls into disrepair. So you're in a situation where the roof caves in, or you maybe a wall collapses. It may be more difficult for you to send contractors in to repair that wall. You may have a situation where actually the building's just a bit shabby, and it's impossible to send contractors in to carry out the necessary redecoration works. But the contractual position is, if the lease says you're obliged to keep common parts in repair, you're in breach of that obligation as soon as it falls into disrepair. So slightly harsh in the current climate, but a reality. That argument is challenged, or is open to being challenged. A lot of people think it's wrong. There's some interesting overture comments and decisions, and I know people are trying to get it overturned or changed in the case of long residential leases, but it remains the case currently. Thankfully, in most modern leases, there are provisions that say that a landlord isn't in breach unless he's served with notice of a disrepair and is given a reasonable period of time to carry out repair works. Again, that'll only be the case if the lease expressly says as much, and thankfully a lot of modern leases do. In that case, what's a reasonable time, I think will definitely be affected by the current circumstances and would be taken into account. So read the lease, I think, is the key point to take away there. But the second point relates to the restrictions on movements and gatherings that can be found in the Health Protection Coronavirus Restrictions England Regulations 2020. And there are two in particular. Regulation 6 provides that during the emergency period, no person may leave the place where they are living without reasonable excuse. And then it sets out the circumstances that might amount to a reasonable excuse. Travelling for the purposes of work, where it's not reasonably possible for that person to work from the place they are living, Regulation 6.2f, and to fulfil illegal obligations, Regulation 6.2h. So, you know, if you have to carry out repairs because a building's fallen into disrepair and it's causing, you know, it's an urgent issue for the occupants, clearly you can't carry that work out from home. So I think that would amount to a reasonable excuse. Regulation 7 is probably an even more important one. That provides that during the emergency period, no person may participate in gathering in a public place for more than 2 people, save in one of 8 defined circumstances, which include where the gathering is essential for work purposes. That's Regulation 7, subsection D. So the $1 million question is what is essential for gathering for work purposes. I'll skirt over the question of whether internal common parts amount to a public place, because nobody knows really. It's probably open to debate. But what is essential is something that a lot of people have talked about. We've got a lot of guidance notes on this actually, and after this webinar, I think you'll be sent a link with the webinar recording, and Raj is going to include links to these guidance notes in that email for you to read. But I think one of the most important ones is a guidance note on landlords and tenants during the coronavirus outbreak. Again, emphasising that the landlord's repairing obligations haven't changed, advising landlords and RMCs to carry out planned inspections where it's necessary to prevent dangerous conditions from persisting. And then effectively it says that people should take a common sense approach to non-urgent issues, i.e. don't really do them unless you have to. With respect to access to leaseholders' apartments, it said that access should be provided where it's reasonable, safe and in line with government guidance. And so, you know, that's likely to be the case if access is needed to repair part of the building, which is a major health and safety concern, for example, or damage which is causing an issue for somebody's apartment, like water ingress. Importantly, it then goes on to say that where it's reasonable, safe and in line with government guidance, landlords should make every effort to review and address urgent issues. And then it goes on to talk about what's urgent. So I think this is probably the most important bit. Urgent is effectively anything which might put somebody's health at risk. So damage to the fabric of building, which is leading to water ingress into apartments. Anything which might affect heating or leave the leaseholder or tenant without heating or hot water. Any issue which might affect the ability of a tenant or leaseholder to have a shower, a bath, use their toilet, wash their clothes. Any security critical issue, such as a problem with a broken door or window, and probably any sort of major fire safety issue as well. So those sorts of things you should be able to do, subject to obtaining contractors to go and do that work. Non-urgent things like redecoration probably best to be left until after the lockdown ends, I think is really the message. And there's lots of other guidance. There's obviously the government's guidance, staying at home and away from others, the social distancing guidance that came out a while ago that kind of reiterates that it's possible for work to be carried out in people's homes, even if they're self-isolating, if it's really, really urgent. you've had quite an interesting guidance from the Construction Leadership Council on site operation procedures and things like that. So, construction works going on, repair works can continue. The guidance doesn't even say that it's absolutely mandatory to stay 2 meters apart. Sometimes it won't be possible, and in those cases, measures have to be put in place to protect the workers. So it's very much a sort of common sense approach. Really, kind of in a nutshell, I think repairs should be carried out where necessary, if required under the lease. However, work should only be carried out where it's urgent and taking all precautions to keep safe. If a landlord or RMC or RTM company is unable to meet its repair obligations, best practice would be to engage in productive talks with the other party as soon as possible. So I'll leave it at that and pass over to Andrew and Nigel to say that's very nice, but in reality, this is what's happening.
You've taken the words right out of my mouth there. That's very nice, but in reality, it's the margin. The margins are where the lawyers make their money, and I say that only with affection, because when something is cut and dried one way or the other, then it's relatively clear. Is water pouring through a ceiling? That's an emergency. Yes, that needs to be done. Internal decoration of an atrium, probably not emergency. But where it starts to get more difficult, and I'd be interested in your thoughts on this, is something like external decoration, because if you don't bring new external decorations, you can have timber that will rot, and ultimately it will lead to deterioration of the building. So when you start to get into the things like that, I mean, do you have any view on that at all? I'm putting you on the spot here, and perhaps that's unfair.
That's an interesting question. Well, I would say, is leaving the external decoration over the emergency period likely to cause such damage to underlying timber and so on that would put people at risk or put their property at risk. If leaving external decorations for 3 months is likely to cause the timber to rot and cause severe structural issues to the building, then I suspect it would be reasonable to go in and do the decoration. But you'd have to take your surveyor's advice about that.
Okay, so what if you've got that then written into the lease? I know you've kind of gone through this, but let's use this as a worked example. You have an obligation to renew the external decorations every 3 years. It's written into the lease. And you take a view, you're not going to be able to get trades onto it during the summer. You're not really going to be painting the windows externally in horizontal rain and snow during the winter. So you're now in breach of your lease in terms of the maintenance of the building. So just use that as an example to articulate the consequences of that and what managing agent should be thinking of.
But of course, you can leave fulfilling a legal obligation is one of the reasons for travelling. In terms of work that's essential for gathering, I think the important thing to realise about the guidance is that it is just that, guidance. It's not the law. There's actually no case law on this at the moment. So you have to take a robust common sense approach to it. That if the lease says redecorate every 3 years, would leaving it 3 months really be that much of a burden? You have to, again, I think you have to take your expert's advice about the impact of that on the building, and your lawyer's advice about what potential damages claims might be made against you if you failed to do that. Often leases will say redecorate as often as reasonably necessary, and what's reasonably necessary will be affected by, again, I think, the coronavirus crisis. So I'm not convinced that cyclical maintenance is essential, I have to say. The restrictions aren't going to last forever. They'll probably last for a couple of months, I suspect, looking at our international colleagues. How difficult is it going to be to carry out external maintenance in the future? I don't know, but I suspect things will go back to normal in 6 months or so. I might be being slightly optimistic, but I mean the reality is, like you say, margins is where lawyers make their living. There's no case law on it. My instinct is cyclical maintenance isn't essential and should be done, but I'm happy to argue the point if anyone wants me to.
Okay.
Nigel, would you like to come in on some of the practical things you're seeing around reactive maintenance?
Yeah, I think a big thing to look at, and we will come on to this a little bit later in the next 3 or 4 sections, but first of all, look at the money. I know that makes me sound like my old profession of being an investment banker, but if you have money then in the service charge account, then you have more flexibility. Obviously, if you're not getting it in, you're going to have to make some fairly hard choices. Things to think about under the current scenario, i.e. we're still in lockdown, things are going to be more expensive to repair. So instead of 2 fat blokes in a white van, you're going to have 2 white vans with a bloke in each, probably. So costs are going to go up. So sometimes putting a cost off would be perhaps the wiser thing to do. Talk to your clients, because what you might think is non-essential to them might be vital. I'll give you an example here. I was talking to somebody and I said, well, gardening, that's a cost we can just slash straight out, not a problem. And he said, well, no, hang on. Take the example of a retirement home where there's older, more vulnerable people there, and looking out on a neat garden is one of the few pleasures they got in life. And that is not something that can be cut. So talk to your clients, because the hard-boiled gardening, might be absolutely fundamental for them. Or frankly, you could be the other way around. You could say, I want to send the gardener in, and they'll go, are you crazy? We need to stop as many people as possible coming into here and keep the costs down. So there's quite a bit going on there. It does tie into a little bit of later on, but Andrew and I spent a long time, and it was actually a very productive time, talking to BIBA lawyers, the Insurance Brokers Association lawyers. And a very good couple of points they made, which does tie into a little bit later on. But if you are making a decision on doing or not doing something, such as a major work, document it, because at some stage you might be asked, why did you do that? And don't sit there thinking, oh God, I can't remember. Say, well, at the time, this is the process I went to. And to be honest, people like trading standards, tribunals, etc., will be a little more lenient on you if they can see why you've done it, even if you were wrong. We're not going to get it right. But there will be instances that the classic one is the lift, where you've decided you to take it out of commission because you can't get it repaired. Somebody falls down and breaks their leg. Why did you take that lift out? Because it does represent a danger. So docket, you will never get it right, but at least you can give it a shot on that. And the secondary thing on there is you might, without realizing it, be invalidating various warranties because you're not maintaining the equipment. So an unintended consequence. That's what we're doing now. I think we are starting potentially to look towards when we're coming out of this. A little bit prematurely is my personal opinion, because I'm certainly not immune to COVID yet. But start thinking about that, because it will take time to come out of this in terms of practical. So if you've got, again, we'll use the example as a pool in the basement, government turns around and says, right, we're back, lockouts down, people are going to be sending their kids down to that pool. It won't be ready. It'll need to have the chlorine inspections, all of that sort of stuff. So think about those, think about your suppliers. So those to me would be the practical points. If you have the money and can get work done, there's no reason not to do it, as long as it doesn't cost too much, because the secondary thing here is you're trying to keep suppliers in business as well. That's a consideration to think about, but not put them in danger, so they don't feel they have to be obliged to send people. I know I've flipped and flopped there, but it is. We've got a very heterogeneous situation here. Every building is different, every client is different, every situation is different. It's the awful thing that the property manager's got to try and figure it out on the hoof. But I think those are some of the things you've got to go through. But again, I think the one thing, I'll stress it again, talk to your clients.
I'd like to just add one thing we're seeing from a reactive repairs trends perspective. So as the coronavirus epidemic hit, residents took government guidance or a steer to be pragmatic in terms of what they were reporting for reactive repairs, and we saw non-urgent repair volumes drop in emergency and urgent repairs volumes hold. There's been a change in the past week, and it's been absolutely stark. I think it sort of goes to Nigel's, I think, possibly first point on this, is that we're going through waves or a circle in the way in which people are viewing themselves. So through that anger cycle, through acceptance and background, we're seeing a real spike in non-emergency repairs being reported again. And to Nigel's point, I reported this a few days ago. Why has it not been dealt with? So it's just something that sort of the data is tying back to that sort of human emotion and the cycle that we're seeing. Depending on how long this lasts, we may see it go back down. But throughout this, emergency repairs have continued to be reported broadly in line with historical trends.